Hello everyone, welcome to another episode of Talking Legal with TEMPLARS. My name is Adebimpe Mosanya, an associate in the Energy and Natural Resources Practice Group here at TEMPLARS, and with me is Ifure Udofa, a senior associate in the Energy and Natural Resources Practice Group here at TEMPLARS. Today, Ifure and I will be discussing a pertinent issue in the Nigerian oil and gas industry, which we believe will be beneficial to our clients, stakeholders, industry players, and every person interested and involved in the Nigerian oil and gas industry. Our topic specifically is boosting Nigeria's economy via domestic crude oil and gas supply and delivery compliance. Now, our discussion will focus on the combined effect of the Petroleum Industry Act 2021, the Production Curtailment and Domestic Crude Oil Supply Obligations Regulation 2023, and the Domestic Gas Delivery Obligations Regulation 2022, and of course its implication in the Nigerian oil and gas industry. Now, to delve into our discussions, Ifure, we have specific questions for you to answer. Now, from the titles of these regulations, that is the 2023 regulations and the 2022 regulations, we can see that there are specific obligations within these regulations. Now, can you please shed some light on what these obligations are?
Okay, thank you very much, Adebimpe. Thank you for having me here.
You're welcome.
For crude oil, right, the expectation is that NUPRC imposes a domestic crude supply obligation on LEC. And this is supposed to happen upon compliance with a process laid out in the PIA and then also in the Domestic Crude Oil Supply Obligations regulations. There are also guidelines which have been issued for this purpose. Now, once this has been done, right, it simply means that a lessee or a producer is not allowed to export volumes, except volumes of produced crude oil, except it has first of all complied with its domestic crude oil supply obligations.
Okay.
Or it may export all of its produced volumes when there is no demand from the holder of a petroleum refining license, which is really a refiner, right? Now, in relation to gas, it is domestic gas delivery obligations to the various identified sectors of the Nigerian economy, really, which is the power industry, gas-based industry, or power sector, which is the power sector, gas-based industries, and the commercial sector as well. The essence of these regulations really are to, in the case of crude oil supply obligations, to help develop the domestic refining markets.
Okay.
And obviously for gas, on the other hand, is also to develop commercialization, to develop and improve energy prices in Nigeria.
So the Production Curtailment and Domestic Crude Oil Supply Obligations 2023 was just recently issued, and by recently I mean 2023, right? But it then begs the question of what was in place for refineries prior to the existence and issuance of this regulation.
The PA had general...
The PA being the
Petroleum Act,
Okay.
yes, which is the predecessor act to the Petroleum
PIA,
Industry Act.
yes.
Had general stipulations in relation to crude oil supply and refining. What the PIA then did is that it created a framework for NUPRC to be able to issue regulations. So first is that the PIA establishes the obligation that as a producer, as a lessee, you now have an obligation to supply a quantity of your produced petroleum into the domestic market. And then NUPRC is empowered to make regulations to govern this framework. It is in furtherance of these powers that NUPRC issued, so NUPRC being the Nigerian Upstream Petroleum Regulatory Commission, issued the 2023 regulations and have also issued guidelines. In addition to that is what the regulations and the guidelines seek to do are to create a framework or a mechanism for introducing production quotas and also introducing utilization of these production rules around production quotas, rules around utilization of production quotas for the producers.
Thanks for simplifying the intention of the 2023 regulations. You mentioned something about production quota. Can you shed some light on it?
What the production quota really is that it sets a bar,
Okay.
right, for a producer. So essentially, it gives the producer a specific limit or a specific bar to which it can produce. Now, I mean, I guess the point is, if you have a bar, then you should utilize that quota.
Yeah.
Once you are unable to utilize the quota, the producer is expected to inform the commission, right? Failure to notify the commission of the inability to meet that quota will make that producer liable to a penalty of $5,000 a day. And also the producer would also be expected to report that inability to meet the quota in its monthly reports to the commission.
Oh, I see. Okay, so the administrative penalty essentially is $5,000 per day.
Yes.
That's sort of equivalent to about 8 million naira. Okay. Now that you've mentioned bars and limits, do these apply to refineries as well, or is just for the suppliers?
Now, for the refineries, there are obligations which impact the refineries. They have domestic refining requirements, which are issued by NUPRC from information which it obtains from the Nigerian Midstream and Downstream Petroleum Regulatory Authority. That's NMDPRA. You see, the challenge with a failure to meet the quotas is that we then have a scenario where the domestic refiners are unable to meet those domestic refining requirements,
Okay.
right? We are aware, for instance, of one refiner that has, complained of the unavailability of crude oil for it to be able to meet its refining obligations. So even if you don't look at it in terms of obligations, even in terms of operational efficiency for those infrastructure, those are all impacted by that. What the regulations have sought to do, or what the framework seeks to achieve, right, is that NUPRC facilitates a willing buyer, willing seller relationship between the producer and the refiner, where they enter into an SPA, for the sale of crude oil to be able to meet the refiner's requirements.
Okay, good that we have delved into the issue of SPA, right? Considering the CBN's dollarization policy, the 2015, I would wonder that in such transaction, what's the currency of payment?
Okay, simply put, the currency of payment could either be in United States dollars or in the naira, right? But I mean, you would recall that even for the dollarization policy, oil and gas operators were exempt from that restriction.
So speaking of penalties, Ifure, earlier you had mentioned something about the 5,000 daily administrative penalties for failure to utilize production quotas. In these regulations, that is the 2022 and the 2023 regulations, are there other penalties?
Yes. Okay, so first is you have a penalty of $10,000 for failure to meet an RFQ. Now, what the RFQ really is a request for quotation that is issued by NUPRC to a producer. And this is issued when the NMDPRA, which is Nigerian Midstream and Downstream Petroleum Regulatory Authority, informs NUPRC of a shortage, right, of crude oil volumes for refineries. The expectation is that the producer will submit a quotation to be able to supply the volumes to close the shortage or to satisfy the inadequacy within a specified timeline. So where the producer fails to do so, then that producer is liable, so fails to submit a quotation, then that producer is liable to that $10,000 penalty. Secondly, where a producer fails to honor the DCSO obligation, the producer is liable to pay a penalty of 15% of the fiscal price of the DCSO volumes of crude oil that have been imposed on that producer, right? In relation to the domestic gas delivery obligation, the producer will be relieved of liability in circumstances such as force majeure events. Also, inability of the purchaser to pay for allocated gas volumes, or where there is an inability of the purchaser to take those allocated gas volumes.
Okay, so just to focus on our, the topic for today, as to the implementation and the implication of these regulations, that is the 2022 regulations and the 2023 regulations. I want to know the impact, the implication of these regulations from the date of its issuance till now and even in the future.
Okay. I think the first immediate impact, right, is a growth of a market around domestic refining of crude oil. Because Nigeria has always been known to be an exporter of produced crude. This is an opportunity for us to also begin to refine, right? And also, the aspiration is to be able to refine internally, in country, sufficient petroleum products to be able to satisfy the local market. Second impact which comes to mind is the fact that with gas, you have increased commercialization. With gas, you have growth in industries which use gas as feedstock,
Yeah.
and industries which use gas as a power source as well, right? So we are seeing a lot of movement in petrochemical industries. We are seeing a lot of movement in even areas where you have clusters, commercial clusters, industrial clusters, where the availability of gas in the domestic markets is making it possible for those industrial clusters to be able to be powered for their industrialization and commercialization processes. I guess the third point is also to be able to drive down and manage energy prices. Because the availability of gas means that you have feedstock fuel for power generation.
So since the issuance of these regulations, do you think that there are certain challenges in terms of implementation?
Given the sensitivity of the issues, an important point to note, because I really won't call them challenges, an important point to note would be that there should be strict compliance with the processes and the procedures as have been outlined in the PIA regulations and the guidelines, right? Because where that is not done, because of the sensitive nature of these issues, you could have persons who seek to litigate over the implementation of the domestic supply obligations. Second thing which can be a challenge is that, especially in relation to domestic crude oil supply obligations, producers have, in a number of instances, already committed their volumes for financing purposes. So we have a number of forward sale agreements within the oil and gas market. The producer has to balance between settling those financial commitments versus its obligations to supply to the domestic market, right? One would begin to imagine that, there are some tweaking and mechanics which need to happen around that. I guess the third thing is also crude oil sale agreements, sale and purchase agreements are often long-term. So you have producers that have committed volumes to crude oil traders. And those committed volumes would have been committed on the basis of anticipated production, which is really, at the time of those commitments, were not impacted by the domestic crude supply obligations which you then have. So these are some things which, would have to be worked out in the coming days just to be able to give effect and implementation to these policies.
I agree with you 100%. Ifure, thank you so much for the insightful session. I learned a lot, and I'm sure our listeners did. Till the next episode of Talking Legal with Templars. Goodbye for now.